We'll call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Wheeler v. James, case number 24 AP 032. Representing the appellant, Lori Ann James, is Sarah Starr. Appellee Jacob Wheeler is self-represented.
All right, thanks very much, and good morning, everybody. Mr. Wheeler, you'll go second. We'll hear from Attorney Starr first. So, counsel, if you would please identify yourself and your client and then proceed.
Morning, Your Honors. My name is Sarah Starr, and I represent the appellant, Lori Ann James.
Thank you.
Affirming this decision would create a stark outlier from this court's precedent where a fit primary caregiving parent may lose custody due to a pattern of prolonged interference with the visitation of the other parent, and in a way that casts doubt on the fitness of the primary caregiver. And in this case, there were no such findings, nor could there be, because the evidence and the findings showed that over the 3-year separation, absent any court order, the parents agreed to a nearly equal schedule that they built up to over time for these very young children. And then in the end, the court ordered a schedule that was almost identical to the one that the parents had put in place and that mother was abiding by. And so there was mother's ability to foster ongoing contact with the father was exemplary. And so she was treated as unfit for reasons that are just simply not to be found in the record or the findings. First and foremost, the court faulted the mother for wishing to maintain her right to consent to medical treatment for the children. And the court wrongly and repeatedly construed this desire as interfering with the father's rights and with impacting the relationship between the father and the children. However, that if the court was so concerned that mother consult with father about medical decision, many court orders contain language that the custodial parent will do just that, will consult with the non-custodial parent before making medical decisions. There was no need to strip custody from this mother and to uproot the children from the caregiver who had been their primary caregiver for their entire lives since birth and during the 3 years, during the relationship, and then during the 3-year separation. So this decision can really only be read as a punishment for the mother for her perceived attitude towards the father in the context of the litigation in 2023. It's completely divorced from the best interests of the children. And didn't consider the impact of changing the custodian of the children, and the decision should be reversed. And if there's no questions, I'll reserve the rest of my time for rebuttal.
All right. I don't see any hands, so thank you very much. Mr. Wheeler, can you hear me?
I can.
And we can hear you, sir. You understand you have 5 minutes, and we'll try to give you an alert when you have about a minute left, so please go ahead.
Okay, thank you. I just ask for your patience and understanding, not being an attorney.
Oh, sure. That's all right. Don't worry about that. Go ahead.
Okay, thank you. Okay, I just want to briefly respond to a few of the things that that Attorney Starr just stated. First of all, there was never an agreement about the schedule as it was evidenced in the hearing. That was something that was mandated by Ms. James, and I was I had to go along with whatever she had, the schedule that she created. There's evidence in the hearing, evidence that I presented where I continually asked for more time in the schedule, for changes in the schedule, and was repeatedly denied, if even responded to. The schedule that the court created was a 50-50 schedule, which it hadn't been. It had been something close to that, but they created a 50-50 schedule, and that was the reason that it hadn't changed much, was that they based it on her work schedule at the time, which she testified was working on weekends. So I also would argue that the decision, I saw no bearing on in the decision about her attitude toward me being a problem. I think it was really about the decisions that were made for the children being problematic. Let's see. I don't feel that there is any abuse of discretion by the lower court when they awarded custody to one of two actively involved parents. There's a lot of language about the mother being stripped of custody. I feel that custody at the time should have been equal, and that the court awarded custody to one of, like I said, one of two actively involved parents. I had been involved in the lives of the boys since from prenatal on, actively involved, and that's evidence in the transcript. My brief supports the court's findings, which, sorry. So I'd like to respond to the appellant's response to my brief. So like about her first point is about custody being taken from her. We were both actively involved and should have had equal rights regarding custody at the time. There's the second part of her her response detail, or I apologize. The second part of her response is about the fact that I did not respond to the court making it considering the impact on the children. I feel like my entire brief supported the court's decision, and as far as I understood, impact on the children was the first and foremost importance in that decision being made. There's also an assertion that I stated that the court's findings were confused.
You have, sir, you've got about 1 minute left.
Thank you. I'm almost finished. I made no assertions. I make no assertions that the court's findings were confused, rather that the interpretation of the transcript and decision were confused by the appellant's brief. And that's all.
Okay. And I don't see any hands, so thank you very much. How much time does the appellant have, please?
Appellant has 2 minutes and 11 seconds remaining.
Counsel?
Thank you, Your Honors. So the appellee asserts that the visitation schedule that was in place during the 3-year separation was mandated by the mother. Both of these parents had equal rights to petition the court for an order of parent-child contact at any time, starting from the time of the separation, and neither one did that. Instead, the evidence really showed that they built up to a schedule that over years, and it sounds as if father was not entirely satisfied with that schedule, but what the court ended up ordering was almost identical to that, and that is a concession. The father also admits that both of the parents were, actively involved with the children, and that again demonstrates the lack of foundation for the court's finding that the mother obstructed father's role in these children's lives. I mean, this was, without a court order for 3 years, and then to say that the mother didn't support the relationship is just without any basis in the record. And it seems to be,
You
know,
have 1
conceded
minute.
on appeal.
You've got about 1 minute, counsel.
Okay. So the court did not, and I just want to respond to the final point, the court did not consider how changing the children's primary caregiver, and even though both parents were actively involved, the court made a clear finding that is not contested, that the mother was the primary caregiver. And when when there's a switch and the other parent is made the primary caregiver, there needs to be, under this court's precedent, there needs to be weighing of the impact that will have. And there was no such impact. The impact on these children's lives is, not to go outside the record, is substantial. The court didn't consider the relationship with their mother, with their sister, who was the only other family member that they resided with. And the decision should be reversed.
Okay.
Thank you.
All right. Your time has expired. Thank you. Thank you both very much. Please call a conclusion.